The court is pleased to be here at South Dakota State University for our March term of court. It's a traveling session for us, and before we get started, I'm just going to introduce the members of the court so that all of you know who we are. I'm Steve Jensen. I'm the Chief Justice. To my immediate right is Justice Janine Kern. To my far right is Justice Scott Myron. To my left, immediate left, is Justice Patty Devaney. And to my far left is Judge Doug Barnett, who normally does not sit with us. He's a Second Circuit judge in Sioux Falls, and he's been designated to sit with us on this case because Justice Mark Salter, who will be with us in the rest of the morning after this case, recused himself on this case. And so Judge Barnett has agreed to sit with us, and so we appreciate his willingness to be here this morning with us. Before we get started with the case, I want to first of all express my appreciation to South Dakota State University. President Dunn, the administration, faculty, and staff have been great and have been very gracious to the court as we've spent the week here, and I know we're a bit disruptive, so we appreciate their hospitality this week. The other thing I want to mention, we have a number of high schools here today. And we want to welcome our high school students from Arlington, Brookings, Canastota, Clark, DeSmet, Garrettson, Hitchcock, Tulare, Madison Central, Del Rapids St. Mary, Willow Lake, and Coleman Egan. So welcome to all the students from those schools, as well as the students that are here on campus from South Dakota State. The first case this morning is Peggy Detmers versus Kevin Costner. Appearing for Ms. Detmers is Andrew Damgard and Russell Janklow. Mr. Damgard will be arguing. And then appearing for Kevin Costner is Daniel Ashmore, Stacy Heggie, and Catherine Seeley. And Ms. Heggie will be arguing on behalf of Mr. Costner. Each side will have 15 minutes for your initial argument, and then Mr. Damgard, you'll have a 5-minute rebuttal. You may proceed, Mr. Damgard.
Mr. Chief Justice, members of the court, opposing counsel, it's Mr. Janklow and I's privilege to represent Ms. Detmers here today. She happens to be a graduate of this university. This is the second case that this court has heard between these parties. The first case was argued during this court's March term 11 years ago. I read the summary that was prepared for the public, and it said that this case arises from a contract between the parties. That's accurate, but there's two contracts. There's an express contract from May 5th of 2000, and there was an implied contract, a subsequent implied contract that the trial court found in the original case. In its memorandum decision in the original case, the trial court outlined the issue on page 9 and wrote, quote, essentially, the court must determine whether the parties' words, actions, and non-actions constituted a further agreement, i.e. an implied contract regarding the placement of the sculptures somewhere other than the Dunbar. In its conclusions of law, it also stated that it had to use an implied contract analysis to determine if Detmers and Costner made an agreement beyond their express agreement. So, Mr. Damgard, are you arguing anything outside of that implied agreement, or do you think that that's what you're hanging your hat on here, or do you have any rights under that prior agreement? So we do think there are some rights under the express agreement, but ultimately we think this case and the cause of action arises from the implied agreement, because that's what dealt with the display of these sculptures at their current location. In the trial court, in its memorandum decision, outlined the positions of the parties and wrote, quote, ultimately she, Detmers, testified she did not agree to Tatanka as the permanent home for the sculptures in the absence of the Dunbar. Trial court then outlined Mr. Costner's position, quoted his testimony as saying, quote, but for Peggy, it was a gigantic relief that now they were going to be seen, they were going to be protected, and they were going to be permanent. Page 13 of the opinion, the trial court writes, quote, that Costner realized he could create a permanent display area for the sculptures. Ultimately, the trial court did find the implied contract, and that the terms of the contract would be that Tatanka would be, quote, the final display area for the sculptures. Now, that memorandum decision was incorporated into the trial court's findings of fact. Both were presumably reviewed and reviewed carefully by this court on appeal, and the decision was affirmed. And this court on appeal wrote in the 2012 decision, quote, the circuit court concluded Detmers agreed, as demonstrated by her conduct and actions, to permanent display of the sculptures at Tatanka. Some of the evidence that this court relied upon, that's written in the opinion, was testimony from Costner that he and Detmers, quote, discussed permanently placing the sculptures at a site on Costner's property. So as we sit here today, we know beyond any doubt that the court in the prior proceeding found an implied contract, and that the terms of that contract was for the permanent placement of the sculptures at Tatanka, and that Tatanka would be, quote, the final display area for the sculptures. As this court is well aware, implied contracts are recognized by statute in South Dakota. They're every bit as enforceable as a written or oral contract. They're every bit as breachable as a written and oral contract. So our position is a simple one. If an implied contract was found by the trial judge in the prior case, and that decision was affirmed, and the terms of that contract were to display the sculptures at Tatanka, and that Tatanka would be the final display area for the sculptures, then a party unilaterally moving those sculptures would be in breach of that implied contract. And Costner unequivocally stating that he's going to relocate the sculptures would be a repudiation of that implied contract, and we can treat that as a breach.
There has not been an offer received for the sale of the property, so do we have truly an anticipatory repudiation here?
We do, because we have an unequivocal statement that he's going to relocate them. There's always going to be some, I don't want to say condition, but there's always some possibility that somebody might not follow through with the repudiation. They might retract it, or it may not come to fruition. But if it's unequivocal and it's in writing, it's a repudiation. And beyond that, this is in the appendix, but we asked them to admit in their request for admissions that they're going to move the sculptures, and they admitted that. So we think it is a repudiation.
So there was a finding in the first case that stated that the parties had a phone call and agreed to place the sculptures at Tatanka. That seems to be more in the nature of an express agreement than an implied agreement, doesn't it?
Well, I think, yeah, it would sound like an oral agreement.
Right.
It certainly would be an oral agreement. However, the trial court found that there was an implied agreement, and whether the trial court was right or not really isn't at issue here, because it was affirmed. So
you think we're bound by that finding of an implied agreement in this case?
I do.
So then if there's an implied agreement, one of the things the court said, and of course our rules of law state that when there's an implied contract, you've got to look at what the parties' conversations were, what their actions were. Doesn't that seem like a fact question rather than a question of law?
No, because the trial court did that in the original proceeding and then ultimately concluded that the implied contract existed and that the terms of the contract were to place the sculptures permanently at Tatanka, that it'd be the final display area. So it was a fact issue then, but he made that factual determination, and that factual determination is final. So the only real question now is whether it was repudiated, whether that implied contract was repudiated. And I have to point out, with respect to this whole issue of permanence, the trial court didn't come up with that on its own, and neither did this court on the appeal. That was the finding that Costner asked for. Just a few examples amongst many. In his proposed findings of fact and conclusions of law in the first action, finding of fact number 12, quote, during the January 2002 telephone call, Detmers and Costner agreed to permanently display the sculptures on the Dunbar property. Proposed finding of fact 33, Tatanka was an agreeable location for permanent display of the sculptures. Proposed finding of fact 42, Costner believed the sculptures would be at Tatanka for all time. Proposed finding of fact 55, Detmers agreed to Tatanka as a permanent site. Proposed finding of fact 57, Tatanka was a standalone permanent site for the sculptures. Proposed finding of fact 58, the sculptures were to be at Tatanka for all times. And then proposed conclusion of law 5, Detmers and Costner had an implied in fact agreement that the sculptures are agreeably displayed elsewhere at Tatanka.
So you submitted those proposed findings from the first case in your appendix. They weren't included in your motion for summary judgment for the circuit court, though, were they?
They were. At the hearing, the circuit court took them into evidence.
So the court took judicial notice of that entire file?
Yeah, the court actually had us mark it as an exhibit and took it into evidence.
So everything in your appendix was received by the court?
To my knowledge, it was either filed with the court. In that instance, that's the only piece of evidence that he received. I don't think he had to receive it as an exhibit, but he did.
And you're talking about this second go-around? The
second go-around, that's correct, yep. And to be clear, those were Costner's proposed findings in the first action.
Right.
So to the extent I think that Mr. Costner views this issue of finality or permanence with respect to the display as a problem, it's clearly a problem that he created. He asked for that finding and he received it. Because the finding of the implied contract to permanently display the sculptures isn't subject to challenge in this action, what they've really done, what they really argued is the only thing they could do, and that's to sort of redefine, ignore, or mischaracterize the findings. For example, they just parse out one half of one sentence in the memorandum decision in the original action that said that Detmers was, quote, agreeable to the sculptures at Tatanka for the long term. They ignore, however, that the court in the memorandum decision was clear on what it meant in terms of long term because the court used the word permanent on 4 different occasions, and with respect to the implied contract finding, the court used the word final display area.
Counsel, can you address, you said you believe there are some provisions of the express written contract that also come into play here in the issue in this case. So now we have an indication from Mr. Costner that he does intend to move the statutes. Do you think there are provisions in the written contract that address this scenario currently before the court?
I do. Paragraph 3 set forth what would happen if the sculptures were not agreeably displayed in the absence of the Dunbar. And that paragraph provides what essentially puts Mr. Costner in a position that he would have been in prior to the contract. He has to sell the sculptures. He recoups all of his costs in creating the sculptures. To the extent there's any profit, he receives half of the profit. But the most important thing for Ms. Detmers is that she get her copyright back.
And that's what I wanted to be clear of. So that's the remedy that you're seeking here.
Correct. Yeah, I think
because they would no longer be agreeably displayed elsewhere, then that triggers the provisions in parcel or in the third provision.
That's correct, Justice. Okay. Other rights she would have, obviously, from the express contract are the royalty rights.
So did the court find that in the first action that implied contract that you've described here today, the remedy for a breach of that goes back to paragraph 3?
Actually, the court found in the first action that because the implied contract existed to agreeably display them at Tatanka and that it would be the final location that he didn't have to sell them. That's how he prevailed in the first action. That finding is the sole reason he prevailed in the first action. And with respect to the express contract, if you were to boil it down, it's 5 pages or 5 paragraphs, but it really, the subject matter is just only 3 things. It's display of the sculptures, royalties, and the marketing of royalties. Her compensation was tied to royalties from fine art reproduction sales.
Can I just follow up again? I'm having trouble seeing if the remedy you are seeking are the provisions in the third provision of the written contract. Why does the prior implied contract matter, if it was a permanent agreement or not? If we just go back and apply the terms of the express contract, there's no longer an agreement as to where they're being displayed, so those are triggered and that's it. Why do we even have to consider the implied contract?
Yeah, and I think this is a good question. I don't think you have to necessarily. If they're not agreeably displayed, they have to be sold. However, their argument in this case is that he was discharged as soon as he procured her agreement. So, that's where the implied contract really comes in. It's very important. As he wasn't discharged, what were the terms of the implied contract? What were the terms of their agreement? And the terms were to put them at Tatanka permanently.
And as I understand opposing counsel's argument, they are of the view that the provisions in that third, the language in the third provisions had a time component, and once it was agreed at that point, then then we're excused from any further. Can you respond?
Yeah, and so there's paragraph 4 is another display requirement, which required that the sculptures be displayed within 3 years if the resort was not completed. So they were going to go somewhere. We just didn't know where. Paragraph 3 deals with what happens if the Dunbar isn't built within 10 years, and in that instance they had to be agreeably displayed. But the way I understand their argument is that once they were displayed, he was discharged. He was free to do whatever he wanted with them.
And do you disagree with that?
I completely disagree.
And what's your
with that.
basis for that?
It would completely nullify her royalty rights, which was a significant amount of the compensation she was to receive from creating these sculptures. If you want an idea of how significant, if you look at paragraph 1 of the express contract, it notes that he's paying her $60,000 to transition into other work because she'd spent 6 to 7 years doing nothing but these sculptures and hadn't taken on any new business. But you'll notice if one reproduction in the life scale is sold, he doesn't have to pay the $60,000. So you know that her royalty rights on at least on just one sale of reproductions would be a minimum of $60,000. It'd actually be significantly more than that. But that contract, it does indicate that in paragraph 1. So yeah, it would nullify her royalty rights altogether. This court found that she had display rights. That's in the 2012 opinion. It would nullify those display rights to just procure her agreement and then turn around and move them. But more importantly, it would violate the terms of the implied contract as found by the trial court in the first action, which was permanent display, permanent and final display.
So, counsel, you're seeking reversal of the summary judgment order. Are you seeking remand then for parole and extrinsic evidence? How do you see this playing out under your view?
No, we think the facts are undisputed in this case, and actually what makes this case a little easier than most is they're not just undisputed. Most of them aren't subject to dispute because we had the first action and we had the first appeal. So we're asking that this court enter judgment in Detmers' favor as a matter of law. It's also been suggested, the trial court suggested it, and so is opposing counsel, that our argument is that these sculptures have to stay at Tatanka eternally. We've never made that argument. I mean, that's sort of a philosophical argument as opposed to a legal one. We're not saying that the sculptures have to survive the next ice age. What we're saying is if you have an implied agreement that they permanently be there, and that's their final location, that you can't unilaterally move them or repudiate it without breaching it. And he's never had to leave those sculptures there eternally. I mean, he could have sought her agreement to move them somewhere else. He didn't. He could have offered to buy her royalty rights, which is set forth in the contract. Then she wouldn't be dependent upon him to earn any royalty rights. He didn't do that. And of course, he left himself an out in the third paragraph. If these weren't agreeably displayed, he could sell the sculptures, recoup all his costs, and give her the copyright back.
Your time is up, Mr. Damgard.
Thank you.
Thank you. Ms. Hege, you may proceed with your argument.
May it please the court, counsel. Ms. Detmers is here asking you to enforce an implied contract that only has one provision, that the sculptures remain at this location permanently. For the remedy, which Ms. Detmers seeks, she wants to go back to the earlier contract and ask for that remedy to come over to this new contract. That is not allowed under any sort of contract here. Over 10 years ago, a court ruled that Mr. Costner had fully satisfied the contractual obligation that Ms. Detmers based her current lawsuit on. She cannot now resurrect that satisfied obligation or ask this court to impose new obligations not within that contract itself. To do so would defy the principles of res judicata and the most fundamental basic contract principles. The court below didn't even have to get to the merits of this case. It dismissed Ms. Detmers' claims on the basis of res judicata, which prevents precisely what's occurring here, repetitive litigation on the same issue. Ms. Detmers isn't challenging two of the factors of res judicata, but she does contest the application of the other two, looking at whether the question in the prior litigation is the same as the one here, as well as whether there was a full and fair opportunity in the past litigation to address what she's here today on. The question in the prior litigation was simple: whether Mr. Costner had satisfied his obligation under paragraph 3 of the May 2000 contract. The court in that case answered yes, it had. This court on appeal affirmed that decision. Therefore, Mr. Costner is discharged from his obligation pursuant to paragraph 3. Ms. Detmers tries to parse out what was actually involved in that litigation, saying, well, we only looked at whether Tatanka was elsewhere, whether we agreed, but the fact remains the court looked at paragraph 3 and the satisfaction of that paragraph. As to whether there was a full and fair opportunity, Ms. Detmers points to subsequent facts that have occurred after the circuit court decision, which was affirmed on appeal. But the circuit court's decision affirmed that Mr. Costner is fully performed under that paragraph, makes any subsequent facts irrelevant. Moreover, if she wanted to argue that there were any continuing obligations under that paragraph, she could have and should have done so at that time. Clearly, at the time that she brought that prior lawsuit, she did not agree anymore to the placement of the sculptures at Tatanka.
Was that really relevant at the time? The question was, they already had the sculptures at Tatanka at that time, correct? Mm-hmm. And the only question in front of the court was, did the parties agree to put them there? The court found yes, and the court found, pursuant to paragraph 3, that was located elsewhere. Didn't get to the question of what happens if Mr. Costner wants to move them. Would you agree?
I agree with that, Your Honor, but that's precisely what claim preclusion is meant to address. She could have argued that her continued consent was required, that her continued agreement to that placement or any placement was required under that paragraph 3.
That's contrary to the arguments of both parties in the first time around, which was this is the permanent location. Certainly Mr. Costner's argument was, this is the permanent location, I'm going to keep them here. That's what he argued throughout that case, and that's what the trial court found and affirmed by the Supreme Court. So wasn't that really the only issue, is are they going to be at Tatanka?
Yes, Your Honor, but what could have been included in that earlier litigation is what we're here on today as well. That could have been addressed. The reference to the permanency of the sculptures, I know that word has been pointed out by Mr. Damgard as used in this court's prior decision, but that was merely to offset and to counter Ms. Detmer's claim that that was a temporary or an interim placement of the sculptures. To work against that, the court used terms such as the long-term placement, permanent placement, but ultimately the court found that that contract provision was fully satisfied and Mr. Costner had fully performed under that contract.
So Mr. Costner put about $6 million into developing the property around Tatanka. There's a gift shop and a visitor center and so on. So how was his unilateral right to again move it squarely before the court? And I know that you've just discussed that with the Chief Justice, but I'm looking for the evidence in the record on that point.
The contract simply states that the parties agree to display it elsewhere. The court found that that happened. There is no plain language in the contract itself that requires further subsequent agreements for any relocations. I think the remedy itself in paragraph 3 indicates that really they were only looking at that initial placement. If there wasn't a placement elsewhere, the sculptures would be sold. Mr. Costner would be able to recoup the costs for the commissioning of the sculptures, the costs for the sale of the sculptures, and they would split the profits. That didn't happen. They did agree to display it here. Mr. Costner put in, like you said, $6 million to develop these sculptures as the focal point, going above and beyond what he was required to do. So the remedy of that paragraph itself shows that it was merely limited to that initial placement.
Your argument as to issue preclusion seems to be that she should have anticipated that he would sometime in the future not consider this to be a permanent placement. Is that correct?
Yes and no, Your Honor. With issue preclusion, the court found that he had fully satisfied his obligation under that. Therefore, that was swallowed within the judgment. Res judicata applies. Subsequent facts don't come into play and don't affect that earlier decision.
How could the court have decided that he has permanently displayed it if he hasn't permanently displayed it? I mean, how could the court have decided at that time that he had fully complied with the obligation to permanently display, which the court clearly found?
The parties under paragraph 3 would have had to agreeably display it elsewhere. The court found that happened. The paragraph is satisfied.
But where in the provisions of paragraph 3 do you think it clearly states a time component with regard to the agreeably displayed elsewhere?
There's no plain language in the contract that identifies that time component. It just, again, indicates that they must agreeably display it elsewhere, which has been found.
So if there is no time component, and now we're in a situation where one party wants to display it elsewhere, if the other party disagrees, we have a disagreement, so why then don't the provisions, the remedial provisions in that contract come into play?
Because you have to look at the plain language of the contract, and they don't cover that continuing obligation. Ms. Detmers and Mr. Costner could have negotiated that. Each was free to do so, but they did not. They did not include a provision with respect to continuing rights. They clearly knew how to with respect to other provisions where there was an ongoing right associated with an obligation, but they did not include that in paragraph 3. And again, the remedy there, if you interpreted it as forever applying and forever requiring an agreement into the future, the remedy there wouldn't allow Mr. Costner to even recoup any of the funds that he had put into subsequent placements every time they're moved. $6 million for this placement at Tatanka. It would require him to put in all of this money and never be able to recoup that.
But you have to read the contract. You can't read paragraph 3 in isolation. If you go back to paragraph 2 and the agreement says that Mr. Costner drafted, as I understand it, says that Ms. Detmers is going to continue to receive 20% of the profits from any sales of reproductions. And that's permanent. And there's no question about that in paragraph 2, ongoing. So if Mr. Costner now moves them from Tatanka and puts them in his backyard, there probably aren't going to be any reproduction sold. So that would seem to suggest that the parties intended some sort of an ongoing obligation so that paragraph 2 is meaningful. Would you agree?
I would say, Your Honor, that question isn't before the court at this time. There are so many unknowns, hypotheticals involved in that it's hard to see how that could play into the express terms of the contract.
So does that suggest an ambiguity in the contract?
It may, Your Honor, and in fact, Mr. Costner in the prior litigation took the position that the contract was ambiguous. Ms. Detmers had argued that no, it wasn't was unambiguous, and so therefore parole evidence should not come into play. The circuit court in that earlier litigation sided with Ms. Detmers and agreed that it was unambiguous to prevent parole evidence coming into play to address any ambiguities.
Specifically, what do you think is ambiguous in the contract, the written contract?
In that prior litigation, I can't quite remember what Mr. Costner was contending was ambiguous.
Currently,
I would say it's unambiguous. There's no continuing obligation under paragraph 3 that the statutes for subsequent relocations be continued to be agreeably displaced elsewhere.
Are you suggesting that there's anything about the 10-year provision relating to the Dunbar not being built that applies to the agreeably displayed elsewhere? Because I'm still having trouble understanding why you're thinking that's not a continuing obligation.
No, Your Honor. With regard to the 10-year, I mean, we're really looking at paragraphs 3 coupled with paragraph 4, and that was the basis of the first litigation where she was trying to put it into paragraph 4 instead of paragraph 3. But for purposes of paragraph 3, the language is what it is. Like the lower court, she had indicated it was unambiguous, and there's just no indication of when that this would have to go on forever. That would lead to an absurd result, and this court, in interpreting contracts, I believe under the Union Pacific case, indicates that it must still be reasonable. It can't lead to an absurd result, and requiring Mr. Costner, his heirs, to always, forever continue to agree to the display of the subsequent relocation, for then Mr. Costner to put all of this money in that he would never be able to get back under the terms of the agreement, because it was just to address the initial placement, that would be an absurd result. And in addition, Ms. Detmers herself has anticipatorily repudiated her contract requirements and obligations. She has said she has not and will not agree to an alternative placement in the prior verified complaint in her sworn statement. Now, she has never backtracked that assertion, that a sworn statement that no, actually she will come to the table in good faith and fair dealing and do that. That has not happened. So at this point, Ms. Detmers has anticipatorily repudiated and breached that contract. Mr.
Counsel,
Costner.
Was that argument raised in the prior litigation? Ms. Detmers, anticipatory repudiation?
I don't recall, Your Honor, off the top of my head. I would say it's certainly not waived, and we're not barred from doing it because it remains there today. And if the court were to look into the contract itself, the sworn statement has never been withdrawn. She could have said, no, actually, I will look at other areas. She has not done that. So therefore, that anticipatory breach repudiation remains and relieves Mr. Costner of performing under the terms of that agreement.
Well, the contract doesn't require her to agree, does it? I mean, the contract instead seems to have provisions that come into play if they don't agree. So if they can agree, then he's the owner. He ultimately gets to make the determination, and then there are remedies or provisions that kick in if they don't agree. It seems like that's the point of these provisions, isn't it?
Your Honor, I would say even though the contract doesn't expressly provide it, in every contract there's implied covenants of good faith and fair dealing for each party to get what they bargained for, to go along with what's provided here. The term that, they come and look at whether they can find an agreeable placement elsewhere, that's where that implied covenant of good faith and fair dealing kicks in.
But wouldn't that go more toward requiring them to sit down at the table and attempt to agree?
Yes, Your Honor, and here she's saying, no, I absolutely won't. And that's her statement that remains here today.
So in your view, the remedy for that is what?
The remedy for that would be Mr. Costner is, excused from the contract for further performance because it was a material breach, and that would be under FB&I Building Productions Incorporated. That where there's a material breach of the contract, the non-breaching party is excused from further performance.
But the parties never engaged in any extended negotiations on where it should be moved to or anything. That essentially was her opening bid in the bargaining, correct?
For purposes of this?
Of the second case and Mr. Costner's decision to remove it from that site.
So this case was brought off of a real estate listing offering the property for sale that included a little blurb that says sculptures will be relocated by
and I understand you have an argument that he didn't anticipatorily breach by listing it with the argument, but I'm talking about whether she anticipatorily breached by saying, as her opening position in bargaining, no, I'm not going to move it anyplace else. That wasn't necessarily her final position. You seem to be suggesting that she violated her obligation of good faith and fair dealing by simply stating as her opening position, this is where I'd like the statues to remain.
It's that she won't agree to any further placement, and that was in the first first litigation, that was the first verified complaint where she said she will not agree to this place and she will not agree to any alternative placement. So aside...
Your time is up, Ms. Hagee.
Thank you, Your Honor.
You have a 5-minute rebuttal, Mr. Damgard.
Thank you. The obligation was ongoing, and I agree with you, Justice Devaney, that you can look at paragraph 3 and conclude that in the absence of the Dunbar, wherever these sculptures are displayed, it has to be agreeable. But to the extent there's any doubt, and to the extent that they're going to put forth this notion that once he procured her agreement, he could turn around and move them wherever he wanted the next day, the implied contract eliminates all doubt, because we have a finding in the prior action that Tatanka was supposed to be the final display area.
So clarify that for me. Are you claiming that your breach of contract is based on this implied contract that was determined in the last proceeding, or is your breach of contract claim under paragraph 3 of the agreement?
Well, it's both, essentially. They're not agreeably displayed. The Dunbar obviously isn't built.
But you can't have both. As you know, implied contracts can't exist if you have an express contract.
Well, they can if the express contract doesn't cover the entirety of the subject matter or all the parties' rights. But then again, this would also be essentially second-guessing the original trial court's decision on whether it was appropriate to make that finding. But the trial court made that finding anyway, and made that finding at the urging of Mr. Costner, which is why we think, we have a repudiation as a matter of law. In this case, judgment on liability should be entered in favor of Ms. Detmers. It should be remanded to sell the sculptures in accordance with paragraph 3. With respect to the display rights, again, obviously the royalty rights were entirely dependent upon that. It's common sense that anyone who's going to buy fine art reproductions, especially expensive ones, needs to be able to see and appreciate the sculptures. And you can find more authority for that in paragraph 4, which was the interim display. You'll notice that Mr. Costner switched the royalty allocations. They switched as soon as the sculptures were on public display. So the display was absolutely crucial to the royalty rights. I distinctly remember sitting at that trial. I was just a few years removed from law school. I remember Mr. Costner looking at Mr. Janklow and saying that, look, our agreement was to permanently place these here. They're going to stay on that property regardless of if the resort is ever built. I mean, this was the finding he requested, and I distinctly remember getting the trial court's decision and seeing that they adopted it, and I distinctly remember getting this court's opinion that affirmed that factual finding. She's lived with that for a number of years. But now he has to live with that.
Can we go back to the anticipatory breach issue then? So I understand your position and what the remedy should be, but so right now we just have a statement in a listing agreement saying they will be moved. So it would seem like something actually needs to happen there before those remedy provisions in paragraph 3 would come into place. More than that. So I'm having trouble.
Yeah, it's an unequivocal statement that he's going to relocate them. I guess the only thing that would be conditional is if and when it sells. And I think the whole point of an anticipatory repudiation is that we don't have to wait for the property to sell and then have him move the sculptures. We also, I'm sorry.
Well, I guess that was kind of where I was going. Wouldn't the remedy be contingent on them actually being moved elsewhere?
No, I think that would actually defeat the purpose of an anticipatory repudiation, because in that instance you'd actually have to wait for an actual breach, and the whole purpose of that cause of action is so you don't.
Well, but right now they're sitting in a location where she agreed. So.
Correct, but he's unequivocally indicated that he's going to move them, and he admitted to that in his discovery responses as well. We did have an alternative count. There's a declaratory judgment count in the event.
But you asked for summary judgment on the anticipatory breach issue, and it sounds to me like you're suggesting now there may be questions of fact in terms of whether or not, when he moves them, the equivocation, all those kinds of things. That aren't those really questions of fact?
No, I think it's in writing. It's an unambiguous writing. We don't hold trials to determine the meaning of unambiguous writing. So if we're going to have a trial, I suppose the only thing he would do is testify that he didn't mean what he said in the listing. I mean, he unequivocally said he's going to move them, and he's admitted to that as well in discovery. But the declaratory judgment count was an alternative count that said, alternatively, we want a declaratory judgment that if he sells Tatanka and closes it down and moves the sculptures, that it would trigger paragraph 3.
That we would have to remand. You agree? Declaratory judgment?
No, I think that's also a question of law. If he were to, he's got the property for sale, he claims he's going to move them, I think you could enter a declaratory judgment that in the event he sells Tatanka, closes it down, and moves the sculptures, it would trigger paragraph 3. I think you could do that as a matter of law. So, but ultimately, I mean, the only thing we're seeking is equality. Application of that factual finding equally to him as it was applied to her, and we'd ask the trial court's decision be reversed. Thank you.